The ACT appears to have one last invitation round to issue, as it recently published its figures for the latest round on the 30th of May. But the numbers are tight, with 888 of the 1,190 places already used and only 54 left for the 491,800 places available. Good luck to all of those patiently waiting. South Australia has opened a registration of interest program for those interested in gaining a nomination for the 858 National Innovation Visa. In gaining nomination approval, it means the state is nominating you to be selected, but it does not guarantee that you can lodge the 858 visa. For all 858 applicants, they must place an expression of interest in the Immigration Department system and then wait for an invitation to apply for the visa. Of course, not everyone who lodges an EOI will receive an invitation. It certainly won't hurt though, so if you need a good nominator, a state government is a good place to start. The Australian newspaper reported that the Australian Skills Quality Authority, known as ASQA, sent notices out to 4,200 former students to prove why their qualification in child and aged care should not be cancelled. ASQA is continuing on its dodgy college cancellation mission. These former students who received their qualifications are between January 2024 and May 2025. ASQA claims that these qualifications should be cancelled according to the article, given the potential safety risks to vulnerable members of the community. According to the Business Standard publication, 98,019 Indian nationals entered the 462 visa work and holiday ballot. This is along with 34,161 Chinese and 7,453 Vietnamese nationals, bringing the total to nearly 140,000 registrations. Since it costs $25 each they pay to place themselves on the ballot system, the government has scored about $3.5 million. Not bad for just setting up a basic IT platform to let people enroll and pay money. The question is, who is picking out these lucky visa winners? Is it some computer that selects the winning tickets, or do they all go into some spinning ball for a good shake? The Lord Mayor of Melbourne in Victoria, Nicholas Rees, wrote an opinion in the Sydney Morning Herald this week titled Dumb, Dumber and Dumberer, Time to Wise Up on International Students. In the article he states, "For the record, here in Melbourne we want more international students, not fewer. Foreign students are very welcome here. They bring vitality and smiling faces to our city, and they help fill labour shortages. They stimulate new construction and housing activity. They create new friendships. They become lifelong brand ambassadors for Melbourne. And they provide a massive boost to our economy." Amen to all of that. Last week we spoke about how you must be careful in answering the questions on the points-based visa's expression of interest. Well, this week we discuss another danger point in the actual lodgement of your points-based visa application form. It is essential that when you lodge your visa application, you must be able to obtain the points you claimed in your EOI. Otherwise, your application will be refused. There is a specific law in place to prevent applicants from overinflating their expression of interest score, ensuring they have received an invitation in a fair and equitable manner. When your application is opened by a government case officer, they will assess your answers and documents you have provided in the visa application. If their assessment does not match your EOI score, then the outcome is a refusal notice. They will not send you a letter warning you that the score you have totaled does not reach your score claimed in the EOI. No, it's just boom. You get a refusal letter in the mail. This is why it's crucial that there cannot be any errors in your application form that may result in you being issued a lower point score. However, the problem is that when it comes to typing up the visa application form, it ultimately does not reassess your points. and this is a major fault in the system.
Huh?
And while yes, it initially provides a summary of those points you claimed in your EOI and asks you if you would like to modify them, of course most people say no. However, when you finish typing up the application form, it does not come back to you with another summary of the points you have claimed. This limits your ability to check that the points claimed in your EOI and the points claimed in your visa application actually match. In the summary, the system allows you to review your answers before lodging, yes, but there is no new points summary table. If you make a mistake, such as typing no instead of yes, then when you complete the application form, the system does not warn you that the information you have provided would result in a points calculation less than what you claimed in your expression of interest. In reality, there should be red flashing lights shouting at you, warning you of the danger ahead.
Danger, Will Robinson! Danger! No, Will Robinson! Danger!
At the very least, there should be some kind of message popping up saying, you claimed 90 points in your expression of interest. However, based on the information you have provided, we calculate you only have 85. In this case, your application may be refused. Unfortunately, many people submit their applications unaware that they have made an error in completing the form, which could result in them receiving a fewer point score than they claimed in their EOI. It's very disappointing to hear such refusal stories after applicants spend so much time and money to lodge these applications. Additionally, many of them have undertaken a length of journey of studying and working in Australia and have even relocated to regional areas to obtain state-sponsored invitations. This failure to inform applicants that their application does not align with their EOI score is a significant oversight within the points-based visa process. The Immigration Department knows of the problem because they consistently refuse applicants for making minor errors in their application. However, rather than fixing the issue, they seem content to issue refusal letters, keeping application fees and forcing people to try again, if of course that is even possible. We can improve this system to ensure that we are not losing valuable applicants with the skills that we need in this country. And now a quick question and answer from one of our viewers' comments. Dean writes in and asks, I'm due to land in Australia next week and will be working remotely onshore for my offshore employer for a period of time. Would this be claimed as onshore or offshore work experience? Dean, that's a good question, and there is policy on this very issue. It states, employment undertaken whilst the applicant is physically present in Australia will be assessed against the requirements for Australian employment and cannot be claimed as working for an overseas employer. There you go, easily answered, and thanks. We are happy to help all of you navigate your migration journeys. Well, that's all for another fascinating week in the world of Australian immigration. Remember, if you need help, we are always here to lend a hand. You can book a consultation online via our website, or alternatively, if you're in a hurry, you can simply call us and we'll see if we can accommodate you. As always, take care out there and I'll see you next time, so bye for now.